Hello and welcome to our webinar, The 3 Ways Employers Misclassify Workers, hosted by the Steely Group. Our guest speaker today is Neil Dishman of Jackson Lewis. Neil is a principal in the Chicago office of Jackson Lewis, a national law firm representing management exclusively in workplace law and related litigation. He helps employers reduce risk and minimize legal costs by giving advice on difficult personnel decisions before litigation ensues. When litigation is unavoidable, Neil helps employers protect their assets and reputations by vigorously and efficiently defending them from employee lawsuits. He counsels and defends employers on a wide spectrum of issues, including race, sex, age, religion, national origin, disability and sexual orientation discrimination, sexual harassment, retaliatory discharge, family and medical leave, and wage and hour compliance. My name is Tracey Goldthwaite, Senior Vice President here at the Steely Group, a national recruiting and search firm where we match awe-inspiring talent with wicked good opportunities. We have a proven track record of success in recruiting and placing highly qualified professionals in direct hire, contract, and contract to hire positions in healthcare, human resources, and clinical environments. We invite you to learn more about our core service areas by visiting our website at www.thesteelygroup.com. Before we begin today, I have just a few announcements. If you experience technical difficulty at any time during our WebEx event, please submit your technical issue in the Q&A panel and we will assist you. You may also contact WebEx technical support at 1-866-779-3239. Please note that as an attendee, you are part of a larger audience today. However, due to privacy concerns, the attendee list is not displayed. All attendees will be in listen mode only throughout the duration of today's web event, and as a reminder, this web event is being recorded. We will hold a Q&A session at the conclusion of today's presentation, but know that you may ask a question at any time throughout the event by entering it into the Q&A panel at the lower right hand of your screen. Neil, welcome and thank you for sharing your expertise with us today. It's great to have you.
Thanks. Pleasure to be here.
So as a quick recap, we're talking about employee misclassification, and we know that that refers to the practice of labeling workers as something other than employees. The Department of Labor defines misclassification as a worker who is an employee under the law but is incorrectly classified as something other than an employee. We know that organizations do this because they see a financial incentive to classify workers as independent contractors. So, Neil, tell us about today's agenda and how the HR professionals attending today can steer clear of trouble.
My pleasure. So we're going to cover, as the title implies, the 3 most common category errors that businesses make when they first take on a new employer, when they put somebody into a new position. So the 3 ways that employers tend to misclassify workers are, first of all, getting the distinction between exempt and non-exempt workers incorrect as far as who's entitled to earn overtime pay and who's not. Second most common error is confusing the distinction between an employee and I intentionally put this in scare quotes, independent contractor, because we're going to talk at some length today about how that term independent contractor can be often unintentionally abused by employers so that they don't treat folks like employees when they really should. And then finally, we'll spend just a little bit of time on a very seasonal topic, given that it's spring and a lot of employers are ramping up intern hiring right now. We want to talk about the difference between a paid employee, in other words, someone that we need to pay minimum wage and overtime pay to, as opposed to an unpaid intern or volunteer, and how to avoid some traps in that area. First, I wanted to spend just a minute emphasizing why this is such an important topic for employers to get right. This nasty little graph right here is the trend in wage and hour lawsuits that were filed in federal court in America over the course of a recent, about a 20-year period. And sorry, the type's kind of small, but if you can see, in 1991, we had about 1,300 of these lawsuits filed in federal court across the country. 20 years later, just over 8,000. So that's roughly a 7-fold increase over the course of 20 years. That is really remarkable. To give you a baseline for that, Your more traditional bread and butter employment disputes, so discrimination, sexual harassment, wrongful discharge, those kind of cases, they tend to trend upwards by about 2% year over year.
Wow.
So a 7-fold increase over 20 years is pretty remarkable. So people often ask me, why is that? Why do we have this big explosion of litigation in this area? Being a good lawyer, I answer a question with a question and say, why did it take so long for this to happen? Because the seeds of it were there for a long time. My own theory for why we've seen such an increase in these kind of disputes is there's a couple factors at work. So one is some of the laws that we're going to talk about today are absolutely ancient. Some of the things we're going to talk about today are laws that have not been meaningfully updated since the Great Depression. That's the original Great Depression, not the one that we just had a few years ago. So think about how different the American economy and workforce is now than it was in the 1930s. And when you take 1930s laws and collide them with the 2017 workforce, it creates a lot of strange pockets where nothing makes sense. On top of that, this is an area where what seems like a small decision or not very consequential decision can, as I say here, metastasize into a large amount of liability. In my business, I find that employers are most likely to be worried about being sued by an employee and to call someone like us for advice when they're getting ready to terminate an employee. That's when they're worried about being sued. And don't get me wrong, that's an excellent time to be worried about being sued and to get some advice on it. My point here is it's not the only time. Most companies don't put the same kind of thought and analysis and care into decisions they make about, for example, whether to make someone an employee or a contractor, or whether to make somebody exempt or non-exempt, as they do in determination decisions. But those kind of decisions can end up being momentous, because if you make a bad decision, for example, about a particular position to make exempt, you end up getting that wrong, or a judge says later that you got it wrong. If you have 50 people working in that particular position, you now have 50 potential lawsuits, or a single class action with 50 participants in it. Bottom line is this is a really good racket for plaintiffs' attorneys to get into. And so there's a lot of ramifications for companies that get this wrong, and they can get socked with liability that they didn't expect.
Yeah. Neil, I mean, those are some really scary trends that you shared with us a minute ago, 7-fold. I mean, that's a crazy, crazy increase. And you talk about those scary quotations. I'm curious, is there a typical average penalty or cost to an employer per employee when they've made this kind of misclassification error?
Yeah, it's a little hard to generalize, but I can give you some contours to that. So in a plain vanilla case where we have a single employee who we classified as exempt from overtime and shouldn't have, and they sue us over that. If the judge agrees and says this person should have been non-exempt and made overtime the entire time, what we're going to owe that person is, in most cases, 3 years of back overtime pay. So whatever overtime we should have paid them over the course of the 3 years before they filed suit. Keep in mind that that number is usually going to be artificially inflated because we typically don't have any records of the hours they worked. We thought they were exempt, and so we didn't make them punch a clock. But now that they're disgruntled and suing us, they have every incentive to say, oh, I worked 60 hours every week, and you can't prove me wrong because you have no records.
Wow.
So that amount of back overtime is somewhat inflated. It goes back 3 years. In the vast majority of cases, whatever that amount of back pay is going to be doubled as a penalty to the employer. It's called liquidated damages. And the employer has the pleasure of paying every penny of the employee's attorney's fees for coming after them for this money, in addition, of course, to paying their own attorneys to defend them from the case. So even in that simple case, when you've got just a single employee complaining about being misclassified as exempt, typically the exposure is at least in the 6 figures. And if we're talking about a class action, even a small class action involving a dozen or 20 employees, it can get to 7 figures of risk.
So burying your head in the sand is not a good option. You got to deal with this.
Definitely not. Definitely not. All right. So with that in mind, let's dig into our first big topic here, which is getting the exempt and non-exempt distinction right. And I want to start with a very basic but often overlooked principle here, which is the law starts from the presumption that every employee in America who works more than 40 hours in a week is entitled to time and a half overtime pay for it. The baseline is everyone gets overtime. The burden is on the employer to prove that any particular employee is exempt from that requirement. That's where those terms exempt and non-exempt come from. This is one of the few areas of employment law where we, the company, the employer, are the ones who bear what we call the burden of proof. Most of the time, if we have a dispute with an employee, such as a discrimination or sexual harassment claim, it's up to the employee to prove that we did something wrong, that we broke the law. When we get sued on this, the burden's on us to prove that we did it right. So first of all, we have the burden of proof. Second of all, the burden of proof is tough to carry. There are lots of Supreme Court cases and so forth over the years that have said things like the employee must plainly and unmistakably fall into the exemption before we can get away with not paying them overtime. I'm a baseball fan, so I think of this like the rule, all ties go to the runner.
Right.
Here, all ties go to the employee. So what we're going to do for the next few minutes here, there's a lot of different exemptions that you can possibly squeeze employees into. Some of them are more obscure or industry specific and so forth. What we're going to focus on here are the four most common ones that any business probably has some people classified or perhaps misclassified as. We sometimes generically call these the white-collar exemptions. So it's called the executive, administrative, professional, and outside sales exemptions. So what I'm going to do over the next few slides here is go over the basics of the exemptions, how the tests work, and then talk about within each one some common traps, so places where we see each of these exemptions most often going wrong. First, though, a pop quiz. And so what I like to do here, just to drive home how counterintuitive this can be, I'm just going to throw a few job titles at you. And I just want everyone listening to the call to monitor your immediate gut reaction as to whether or not you think this would be an exempt position. Or alternatively, if you feel like you know this area of law pretty well, put yourselves in the shoes of someone else in your organization. Okay, your COO, your CEO, a frontline manager, what would they think about these particular positions? Should these be exempt or non-exempt? So let's say we have a widget factory and we have a manager that runs a particular department within our factory and supervises the 10 employees who work in that department. We have an assistant manager of a large retail store, so think of the second in command at a Target or a Walmart or a Big Lots or something like that. An insurance claims adjuster working for an insurance company, large or small. The accounts payable manager in the finance department of any business, really. Or, this one's a little specific, but think about an accountant, so college graduate accountant who's working at one of the big four accounting firms, a Pricewaterhouse or something like that, but is at that first career level, so 2 or 3 years out of college, first rung on the career ladder. The answer to every one of these is maybe. Not one of them is a slam dunk, yes, obviously that can be an exempt position. And in fact, I picked some of these because several of them have been the subject of massive class action litigation across the economy in the last few years. Just to give you an example, that last one, the accountants, every accounting firm that you've ever heard of and some that you haven't heard of have been sued in the last 10 or 15 years over whether or not that entry-level accountant actually meets one of these exemptions or not. Same thing with retail, tons of litigation, some of which I've had the pleasure of handling from time to time, over whether or not assistant managers in retail settings actually meet an exemption or not. So when I said at the top, this is a place where the law is ancient and outdated and often makes no sense, this is what I'm talking about. All right, so with that in mind, let's talk about how these exemptions work. So as I said, we're going to cover four. I'm going to start with the three that are most similar. So the executive, administrative, and professional exemptions each have two big parts to them, two tests. So there's a salary basis test, and that test is the same for all three, so we'll talk about that first. And then each one of them has its own duties test. And for an employee to meet any of these exemptions, they have to pass both of those tests. So we have to pay them on a salary basis, and they have to meet one of the three duties tests. Then we'll talk briefly about a fourth exemption, outside sales, which works a little bit differently. It does not have a salary basis test at all. It only has a duties test. Quick note before I dive into this on difference between federal and state law. Most of what I'm going to talk about today is federal law. I know that we have a fairly Illinois-heavy audience on the phone. There are some places where Illinois law differs or at least possibly differs from federal law, and so I'm also going to try to highlight those briefly along the way. It is more difficult to make employees exempt in Illinois than it is under federal law.
And Neil, perhaps you're going to cover this as you go through this, but I'm curious to know, too, the final rule update that became effective this year, how has that impacted the exempt versus non-exempt dynamic?
Sure. It's put us into a state of great uncertainty because it actually did not become effective this year. It was scheduled to become effective in December of last year, and then a court entered an injunction against it at basically the last minute. That's up on appeal at this point, but while it was up on appeal, the administration changed over from Obama to Trump, and the Trump administration basically still hasn't decided what it's going to do with it. Are they going to support the rule and keep fighting for it, or are they going to drop it entirely, or are they going to come up with a modified version of it? So there is some uncertainty around that, which I'll touch on just shortly.
Great.
Here. Yeah, good question. So let's talk about this salary basis test. To pay someone on a salary basis means that some portion of the employee's compensation has to be a fixed weekly amount that is not subject to being reduced based on the quantity or quality of work that the employee did in that particular week. So what that means in practice is if we have someone we're calling exempt under one of these three exemptions and they show up an hour late today, we can't dock them 1/40th of their pay for the week.
Right.
Same thing if they leave early or overstay their lunch or what have you, because if we do that, then we're not really paying the salary. Now we're paying them based on how many hours they worked or didn't, as the case may be. The amount of this salary, at least for now, is that it has to be at least $455 a week, which works out to $23,660 a year. And that was the big headline that was supposed to change. That amount was supposed to more than double to 47 and change last December. That's what got derailed at the last minute and is still up in the air. At least for now, though, we're still under the old rule where it's $455 a week. Now, there's a few exceptions to the salary basis rule. So a few times when we are allowed to make deductions from an exempt employee's pay for time that they did not work, and here's what they are. So the two most common exceptions here are, first of all, if you have an exempt employee who is absent from work for a full day, not a partial day, but a full day for some personal reason. So they're not sick, they're not disabled, but they miss work for an entire day, we can dock them for that day. Classic example of this is, say you give your exempt employees 10 days of vacation every year, you have somebody who uses up all 10 days of vacation and then takes an 11th day off because they were delayed getting back from their vacation or they need to pick up a kid at school, something like that. So they're not sick, right? They're just out of vacation and took a personal day off. Then we can dock them for that full day. Has to be a full day, though. If they take an afternoon off and don't have any vacation or PTO to cover it, we cannot dock them half a day's pay.
Oh, okay.
You can, and in most instances should, discipline them for an unauthorized absence, but what we can't do is claw it out of the check.
Got it.
Similarly, if you have an employee an exempt employee who's absent for a full day due to sickness or disability, as long as you have some plan that replaces wages in some instances for sickness and disability, you can dock them for this reason. So great example of this, let's say you give your exempt employees 5 paid sick days every year. They use all 5 of them up and then they're sick again on a 6th day. As long as they're absent an entire day, then we can dock their pay for that entire day. Those are the most common ones. There's 5 others that are less often used, but I'll run through them briefly. For an exempt employee, if they work a partial week in their first or last week of employment with you, then you can pay them the proportional week. You don't have to pay them for the entire week if they only work part of it. This one makes me a little nervous to talk about, but I'll talk about it. So in theory, you can fine, basically, impose penalties on exempt employees for violating safety rules of major significance.
Really?
Now, if I was to go to the safety manager at any of your businesses and ask your safety manager, which of the safety rules of this company are of major significance, they would say all of them, right? The Department of Labor has a really, really narrow view of what is a safety rule of major significance. So in the regulation that establishes this, they give one example of when you could fine an exempt employee for violating a safety rule. The example they give is of an employee who is caught smoking in an explosives plant. So that's how significant the rule has to be before we can fine them. So that's why I'm a little nervous talking about that one. It should be used very rarely.
Okay.
If an exempt employee is out on FMLA leave, so you've certified them for FMLA, then you can dock them for their salary for the time they spend out on FMLA, and that one can be in partial days. So that can be hour for hour if they're out on like an intermittent FMLA leave. It does not have to be full days. If you have an exempt employee that is off on jury duty, military leave, what have you, you cannot dock them on a day-for-day or hour-for-hour basis for, say, being on a jury for 2 days. You are allowed to take an offset for whatever money they were paid. So if you really want to claw the $30 or whatever out of their check that they got for being a juror that day, you can do it. It's usually not worth the trouble, but you're allowed. And then finally, the last exception is you can impose disciplinary suspensions on exempt employees for violating written workplace conduct rules. So if you want to suspend an exempt employee for 2 days for sexually harassing somebody or, violating some other policy, you can do that and you can dock their pay accordingly. So that's the salary basis test, and again, that has to be met for anyone who's going to be an executive, administrative, or professional employee. That brings us to the duties test, and so let's talk about those for a little bit. I'm going to start with the executive exemption here, the duties test for that. Let me also apologize up front. I'm going to break a cardinal rule of PowerPoint etiquette here. There's going to be lots of words on the screen, and that's because if folks have the slides afterwards, I want you to have the actual language of the text. And there's a lot of words in it, so sorry the screen is so busy. So to be an exempt executive, this employee's primary duty has to be either managing the entire company or managing some recognized department or division of the company. In other words, when we talk about this job position, we should say the main reason that this job exists is to run that, some recognizable slice of the company. The employee also has to supervise 2 or more other employees. That's full-time equivalents, by the way, so 4 half-time employees would get us there also. The employee has to have the power to hire and fire other employees, or at least to effectively recommend it. So they don't have to have the ultimate authority to just hire or fire somebody on the spot, but they should have a significant voice in hiring and firing decisions, even if they're ultimately made by a group or approved by HR or made at a higher level. This person needs to have a voice in those things. They also have to customarily and regularly exercise discretion, and I'll talk in a few minutes about what that means. And here's where the distinction between federal and state law starts to get tricky. Okay. So believe it or not, Illinois state law on this is such a mess that it's actually ambiguous as to what the test even is to be exempt in Illinois. So understand that what I'm giving you here is the most conservative, risk-averse interpretation of the law. If I'm defending you in litigation later, I would argue that a different interpretation of the law should apply, but for being risk-averse and kind of trying to prevent these disputes in the first place, we're taking a conservative tack here. So taking that conservative tack, in the state of Illinois, if you're going to make someone an exempt executive, they should meet all of these criteria that I just talked about and one more, which is they can't spend more than 20% of their time doing anything other than the other stuff that's already on the slide. So, for example, if you have a supervisor that also does some manual labor or also does some clerical work or something that's not part of this duties test, the time they spend on those lower-level tasks can't be more than 20% of their total work time in Illinois. So that's the test. So where does this one tend to go wrong? We often see situations where there's employees for whom management is one of their duties, but it's not the primary duty, and thus they can't really meet this test. I'll use an extreme example of this. At my law firm, we have a copy room, and there are 3 guys who work in the copy room, and one of them is the copy room manager. Now, if you were to walk into my law firm's copy room right this second, what do you think you'd see our copy room manager doing?
Making copies.
Making copies, yes. That's what he spends 96% of his time doing. He spends the other 4% of his time managing the other 2 guys, right? Someone's got to be in charge, but it's a small part of the job. No way can our copy room manager meet this exemption, okay? Management is one of his duties, but certainly not the primary one. Now, that's an extreme example. You've run into some closer calls out there, but that's one thing we want to be careful with is those working supervisors. We sometimes run into situations where the employee's power to hire and fire others is a matter of pure theory. In other words, the company says to us, well, yeah, I mean, this guy could have hired and fired people. It just never came up. He's got a small department, has low turnover, and so he never had a chance to do that. That's fine. As you can imagine, that's kind of difficult for me to prove in court later, though, that he theoretically could have hired and fired people. So at a bare minimum, we'd like to see that in the job description. Okay. We'd also like to see that this person at least has a role in disciplining employees and giving performance reviews, so the kind of things that can lead to termination decisions. So that's a pitfall to watch out for. We sometimes also get into disputes here about how much discretion the employee really has, and again, I'll talk more about that in a little bit. The types of jobs that are most commonly misclassified as exempt under this executive exemption, they all go by different names, but they're all the same thing. Foreman, crew leader, line leader, shift manager, assistant manager, fill in the blank manager, fill in the blank supervisor. It's that second level up. So if you think about your typical corporate org chart pyramid structure, the bottom of the pyramid, the lower level are the worker bees that don't supervise anyone. If you move up one level from there, so the first line of people who supervise others, that's where you're likely to find people misclassified here. Now, some of those folks may genuinely meet this exemption, but in most companies, not all of them in that second level will. You especially see this as an issue in retail, as I mentioned before, in manufacturing. Those are industries that tend to have a lot of those working supervisors where it's really 40% or 55% or something of their job to supervise others. All right, that's the executive exemption. Let's talk about the administrative exemption. The duties test here is their primary duty is performing some kind of office or non-manual work that is part of the company's management or general business operations. So these cannot be production workers or the people that make your widgets, whatever your company's widgets may be. The way I like to think about this is if your business was a human person, was a body, would this employee work in our business's hands or would this person work in the business's brain? They've got to work in the business's brain to meet this exemption. Okay? They don't make the widgets, they manage the business or some part of the business. They have to customarily exercise discretion and independent judgment. I promise I'll tell you what that means on the next slide. This is a big word salad I don't want you to worry too much about. They have to do one of the following three things. Typically speaking, if they meet the other parts of this exemption, they're going to meet this part too, so I don't want to belabor that. And finally, in Illinois, again, if we're being risk averse, we want to make sure they're not spending more than 20% of their time doing anything other than the other stuff that's on this slide that makes them exempt. So where does this one go wrong? There's a common misconception out there that as long as someone has a bachelor's degree and wears a suit to work and works at a desk every day, they can get paid a salary. The law often does not shake out that way. And if you think back to the examples I gave in the pop quiz earlier, right, so people like insurance claims adjusters, accountants, people with degrees, people that think of themselves as professionals are not necessarily going to meet this exemption or any exemption. We do sometimes get into disputes about whether they work in the hands or the brain of the business. So, back in the 1930s when all these laws were passed, it was everyone in America worked on a farm or in a factory back then. And so it's very easy to figure out who is management and production in your typical factory. Now, for instance, in the tech business, in a knowledge-based business, in our modern economy, sometimes it does get kind of blurry whether somebody's part of management or not. The biggest issue with this one, though, is this phrase I keep using, independent judgment and discretion. And actually the term that the law uses is independent judgment and discretion with respect to matters of significance. That's a fancy way of saying the employee has to make decisions about things that matter. Okay? And the law does give us a couple of pulls to it. The term is as vague as it sounds, okay? But the law does give us a couple of pulls to steer between here. So the regulations say independent judgment and discretion is evaluating different courses of action and choosing one or recommending one. That's independent judgment and discretion. That's to be distinguished from the application of skill, even great skill. So somebody might need a lot of experience and technical expertise and so forth to do their job, but if it's really a matter of just mastering a certain set of requirements or applying a particular skill to a particular problem that's pretty predictable, that's not going to be independent judgment and discretion. Independent judgment and discretion is vetting a bunch of different alternatives and evaluating which one is best for the company. The jobs that are most commonly misclassified here, very often somebody who reports to somebody who meets this exemption will not meet it themselves. So think about all of your functional business departments at your company. The accounting, finance department, IT, deep breath now, the HR department often have people that are misclassified because they're at a kind of entry-level position in those departments. For example, in your finance department, certainly your CFO, right, your controller, people who are doing financial analysis and making financial decisions are going to meet this exemption. But there's somebody in your finance department that just keeps the books and churns out bills and makes the dunning calls and keeps track of your AR and so forth. No matter how skilled or indispensable that person might be, they are not exercising discretion and judgment, right? They're a bookkeeper. So they should not be exempt. Even though this is called the administrative exemption, 99% of the administrative assistants in the world do not meet it, okay? A very high-level executive secretary to a really important person might meet this. We're sitting right down the road from McDonald's headquarters right now, and I'll bet you whoever is the executive secretary to the CEO of McDonald's probably actually doesn't meet this exemption. 99+% of the admins in the world do not, though, and should be non-exempt.
Neil, quick question.
Yeah.
And not being the HR professional on a day-to-day basis, how big of a role do the actual job descriptions play when you get into this dynamic versus interviewing the employee and getting a better understanding of their roles and responsibilities?
Yep. So the job description is a baseline and is often our best starting piece of evidence when disputes come up over this. But it's not dispositive. In other words, if the employee can give some compelling testimony or come up with some evidence that their actual job duties were different from the job description, they may be able to push back against that. It is a good baseline, though, to make sure that you have good job descriptions that are updated, that are accurate, that track some of the criteria we're talking about here. I guess what I'm saying is it's more often that job descriptions hurt us when we're trying to defend these cases, or the lack of a job description entirely hurts us.
Okay.
They're not silver bullets, they're going to win cases, but bad ones or non-existent ones can help lose them.
Got it.
Yeah.
Okay.
All right, we're running a little behind here, so let me skip ahead to the professional exemption. There are two ways to meet the professional exemption. We have what's called the learned professional. So that's somebody whose work requires advanced knowledge, typically represented by an advanced degree of some kind in a field of science or learning. So think lawyers, doctors, other medical professionals, teachers, okay? Or we also have what's called the creative professional. So that's somebody whose primary duty requires invention, imagination, creativity. They're an artist or a performer of some kind. So we have to meet one of those two prongs, and then whichever one it is on top of that, this person also has to exercise discretion and judgment again, and their work has to be intellectual and varied in character. It can't be rote work. And then once again, in Illinois, if we're being safe, we don't want them to spend more than 20% of their time doing anything other than the stuff that makes them exempt. Common problems with this one, there are situations where it's not clear just how advanced the degree has to be to meet the learned professional. Certainly law degree, medical degree, PhD is going to get us there. Most master's degrees are going to get us there. Where it gets hazy is things like a bachelor's degree plus some kind of state certification in a particular profession. Sometimes that works and sometimes it doesn't. Excuse me. Positions that are commonly misclassified as exempt here, I mentioned at the top, junior accountants, junior engineers, social workers is one. So someone that has a master's in social work probably will meet this exemption. Somebody that has a bachelor's in communications and a lot of experience as a social worker might not, even if they have the same job title and are doing the same work. That one kind of sits right on that gray line. Industries at particular risk here is probably obvious from the jobs that I just mentioned. So professional service firms, particularly accounting firms, engineering firms, architectural firms, and what have you, and nonprofits that employ social workers are at risk here. Last exemption we'll talk about is outside sales. And as I said earlier, this one's different. There's no salary basis test here. You can pay this person however you want, straight commission, salary plus commission, draw against commission, whatever. No salary requirement. To meet this exemption, they just have to have two duties. Number one, their primary duty is to make sales, obviously, okay, to be outside sales, and they have to be customarily making those sales or trying to make those sales away from your place of business. By the way, their home office counts as part of your place of business. So if you have a home-based sales worker who just sits in his or her house and pounds the phones for you but never goes out to actually visit or meet prospects, that person is not outside sales. Their house counts as your business for this purpose. Please note, inside salespeople are very difficult to make exempt. Outside sales is a pretty easy and simple one to understand and meet, but the vast majority of inside salespeople cannot be exempt. There is a specific exemption in the retail setting. So for retail stores, certain inside salespeople can be exempt. For example, the folks that are selling you jewelry or makeup or what have you behind the counter of a department store probably meet an exemption. it has some details to it I won't get into here because it's industry specific. There's a couple of other industry specific ones, like I'm pretty sure car salespeople have an industry specific exemption, but for the vast majority of businesses out there, your inside salespeople cannot be exempt.
Neil, I think you're going to talk about independent contractors next. Mm-hmm. Quick question. I mean, obviously, being in the business that we are and certainly paying attention to the news, we're talking a lot about the gig economy, right? Mm-hmm. And they're predicting 40% of the nation's workforce is going to be fall into that description by 2020. Yep. So what do you think we can expect to see in terms of independent contractors and additional laws, and what do you think we're going to see here in the next couple of years around this?
Yeah, so I'm going to talk in the next few slides about what the law currently says about the distinction. There's been a little bit of talk here and there about trying to modernize what I'm about to present here, or to create, even I've heard some proposals to even create like a third category that's in between the two, right? Mm-hmm. So should there be employees and then independent contractors and then something in between for the Uber drivers of the world, right? Right. None of that has gone anywhere yet that I know of, so we're still, again, using these ancient tests that I'm about to tell you about. But that's an area where you might see some new regulations over the next few years. I hope that we will, because the law is just not keeping up with the
trend. Yeah.
Yeah.
Okay.
So another pop quiz, once again, to test your instincts here. So I'm going to give you a factual scenario quickly here. And again, just think about what your gut reaction is to whether or not this person truly is an independent contractor. So you have a highly skilled and experienced professional, not a manual laborer, but a professional who approaches your business. They came to you saying they want to do some contract work for your company. It made sense to you, so you figured out what they were going to do, how much you're going to pay them for it. You even negotiated with them and signed a very nice, long, lawyerly, independent contractor agreement with them, setting out the terms of this contract. No question that both you, the company, and this worker intended this to be a contractor relationship. They didn't want to be an employee. You didn't want them to be an employee. And you paid them on a 1099, didn't give them any benefits or other employee perks or what have you. The vast majority of people who aren't steeped in this area would say, well, yeah, obviously that's an independent contractor. What else do I need to know? So the real answer is we don't know yet. What I just gave you is not nearly enough information to determine whether or not somebody truly can be made a contractor. And that's part of the problem. So everything I told you on the last slide had to do with the party's intent and what their agreement was up front. And that's only one factor out of many that determines whether someone can be an employer or a contractor. Every one of the employment laws out there, the wage and hour laws we're talking about today, the discrimination laws, the unemployment laws, the workers' comp laws, they all have a definition of employee in the statute somewhere. And if a person who is doing work for your business meets one of those definitions, that means they are your employee and they're protected by that law, regardless of what you and they intended or what you agreed on. This is really difficult for business leaders who aren't in HR to wrap their heads around. Right? Because you look back at that scenario and the reaction usually is, well, that doesn't make any sense. We're all consenting adults here. We all knew what we were getting into. This person wanted to be a contractor. We struck a deal with them. We treated them fairly. And now a judge of the Department of Labor, after the fact, is going to turn around and say, nope, that was actually your employee the entire time. Whether you knew it or not, whether you liked it or not, that was your employee. And the answer is yes. That can absolutely happen, as counterintuitive as that is. So here's how to get it right. As I said, there's a bunch of different tests for this. The IRS, you may have heard of the IRS's old 20-point, employee versus independent contractor test. Most of these tests, though, boil down to the same key things. And this, unlike with the exempt, non-exempt stuff we talked about, this is a place where common sense will actually help us get to the right answer as long as we actually apply common sense. So we'll talk about that for a minute. Here's the 4 key questions that I always ask first when I'm trying to figure out if someone should be an employer or a contractor. First question, tell me what factors are going to impact this contractor's profit or loss on the contract that they're going to strike with our company. The answer to that question is very telling. Sometimes I'll ask this question and I'll get a very well thought out, meaningful response back, and we'll be able to rattle off all the different factors that will determine whether this contractor will make a lot of money or a little money or maybe even lose money on their contract with us. A lot of times, though, I ask this question, and the answer I get is something like, huh? Does not compute. Like the concepts of profit and loss don't even make sense here. This guy's he's going to do some work for us, and we're going to pay him for it. And that's when I say, oh, kind of like an employee, right? So that's a bad sign. If the terms of profit and loss don't even make sense on the contract, then we're off to a bad start. Related question number 2. Does this person have a legitimate business behind them? Are we contracting with a corporation or an LLC as opposed to just signing a contract with some dude, an individual person? And is this a real business? Do they have other customers or clients besides just us, right? Do they advertise or hold themselves out to the public as providing these services? Or is this someone who's just going to work for us and nobody else for 40 hours a week? Whatever work this person's going to do for our company, is it ancillary to our business or is it primary? In other words, if you have a widget factory and you want to have an independent contractor deliver your widgets to your customers for you, that person might legitimately be a contractor. We'll have to look at how all the other factors shake out. On the other hand, if you have a widget factory and you want to have a contractor help make your widgets, and in particular work right alongside some of your employees, making widgets along with them, very unlikely we can make this person a contractor. And then the last key question, this is one you may have heard before, is how much control are we going to exercise as a company over the day-to-day nuts and bolts of how this person does their work for us? Now, that's not a yes or no question like some of the others. It's more of a sliding scale, but the more control we're going to exercise over the day-to-day of how they do their work, the more likely they're an employee or should be an employee versus a contractor. Here's some red flags to watch for, some of which I've alluded to already. If you have a contractor but your business is their only customer, they perform work exclusively for you, that doesn't mean they can't be a contractor, but it's a bad sign. Most contractors should have a client base of which you are only one. I mentioned this before. At a bare minimum, the contract itself should be with a business entity, not with an individual person. If you provide any sort of training, tools, equipment, office space, uniforms, business cards, what have you, to this contractor, that's a very bad sign that they shouldn't be a contractor. Think about this in terms of your personal life, and here's where the common sense comes in as long as we apply it. If you have a leaky sink at your house and you hire a plumber to come fix it for you, do you give him training first?
Right.
Of course not. He's a plumber. He knows how to fix your sink already. Does he use your tools? Of course not, right? He's a plumber. He has a plumbing business. He uses his own tools. That's what contractors do. They already have expertise. They already have their own tools, equipment. They cover their overhead. But so it seems easy and obvious when you think about it in the context of your personal life, but sometimes we lose track of that in the business world. Then I mentioned some of these before. If the contractor does the same kind of work that you also have employees doing, that's a bad sign. This one is really bad, yikes. This specific person used to be our employee, and then we quote-unquote outsourced the position, and the same dude is now doing the same work for us as a contractor. That's really, really difficult to defend. Couple of things before we leave this, just so you understand how important it is to get this right. If you have somebody that you're calling a contractor and a court or the DOL or somebody later says, nope, that was really your employee, you're in a world of hurt now. So for one thing, you've been stiffing the IRS because you haven't been withholding wages and Social Security and so forth from their wages because you didn't think they were wages because you didn't think they were an employee. If they've been working more than 40 hours a week for you, you probably have not been paying them time and a half overtime. Who knows if the amount you're paying them, even divided by their hours worked, even works out to minimum wage, right? You never thought about it because you didn't think they were an employee. And you can also get in trouble with your state unemployment bureau. And let me end on this topic on that point, a couple special notes about unemployment. First of all, in the state of Illinois, the IDES, our unemployment bureau here, is very strict on this idea of who or what is the contract with. If the contract is with a business entity, then maybe they will agree as a contractor. But if the contract is with an individual person, they will just automatically take the position as an employee and that they're entitled to unemployment and that you should have been paying unemployment taxes on them. Finally, I also want to say on this, this is most often where these disputes arise in the first place, is in the unemployment context. Here's what happens. Your business contracts with somebody that you think is a contractor. For whatever reason, you then end your relationship with this person. And that cheat goes and files for unemployment. And you're outraged, right? Because you're thinking, this guy's a contractor. He knows he's a contractor. He knows he's not entitled to unemployment benefits. Now he's trying to scam the government. He's going to drive our unemployment costs up and so forth. So in a righteous huff, you fill out your contest form and say, this guy's a contractor. He shouldn't get unemployment. Then your state unemployment bureau says, really? Let's talk about that. And while we're at it, let's talk about these other 20 people over here that you've been calling contractors and not paying unemployment taxes based on. So very often what will happen is you will fight one unemployment claim for someone you think is a contractor, and not only will you lose that claim, but then you'll have an auditor, a tax collector from the Unemployment Bureau coming in, ripping through your books and alleging that you've underpaid your unemployment taxes because you've been underreporting how many employees you have.
And Neil, I know we are just over our end time, but I think, you know what, I think you were going to talk about interns because it is that time of year.
It is.
Why don't we take 5 or 6 more minutes to cover that piece, and then we'll do Q&A.
Sure, and this is a pretty quick one.
Okay.
So if you want to make somebody an unpaid intern, this is the time of year, to your point, when so many businesses just take leave of their senses and assume that if somebody is a student and we call them an intern, we don't have to pay them, and that's how it works, and that's unfortunately not how it works. If you want to have somebody as an unpaid intern, the Department of Labor says the following 6 things all have to be true. The training they're getting has to be something similar to what they would get in vocational school. Now, that's an outmoded term, and the Department of Labor is a little loosey-goosey on that compared to what they used to be. But in other words, the training they're getting has to tie back to their education somehow. The training has to be primarily for the benefit of the trainee, the intern, and not for the benefit of the business. The trainees or interns cannot displace your regular employees. They should not be doing work that would normally be done by your employees. Instead, they should be working under close observation of your regular employees. This one, which is related, is really tough. Number 4, you, the employer, should derive no immediate advantage from whatever work these interns are doing for you. In fact, your operations may well be impeded by having them because your regular employees are spending a bunch of time teaching them and explaining stuff to them and babysitting them and letting them job shadow and so forth. Right? They cannot be necessarily entitled to a job at the end of the internship. That doesn't mean that you can't hire them at the end. You can. You just can't promise that to them up front. And finally, you do have to have a clear understanding with them that they're not going to get paid for this. So it can't be a surprise to them that it's unpaid. So that's the technical test. Here's the bottom line to this one. Think about what your company's motivation is for providing this internship. If the reason you're doing it is almost like a form of community service, so this is something you do because you care, you want to give back to your industry, you want to help people that are in your industry get a leg up and get exposure and be attracted to work at companies like yours, then there's a decent chance you're going to meet those 6 factors and be okay. On the other hand, is the reason you're hiring an intern because you got a bunch of old projects you don't have time for, and wouldn't it be nice if we got some ambitious college kid in here to do them for free? Okay? Because if so, then we're going to have to pay them minimum wage and overtime. They're not going to fit into this unpaid intern exemption. This is a place, by the way, where just generally speaking, in my world, email is the bane of my existence. People put so many things in emails that make it really hard for me to defend cases later, and this is one right here. Right? If you have an email from some manager that says, boy, can we get a college kid in here to help with some of the stuff that I'm backlogged on? Okay? That right there means we've got to pay. Okay? That's a smoking gun, and we cannot make this person an unpaid intern. Last quick note, if we have any nonprofits on the phone here, nonprofits often rely heavily on volunteers, not this kind of unpaid intern concept, but volunteers in general. Just be careful not to overstretch the bounds of that. Nonprofits can use volunteers, but again, they can't be doing the core things that are necessary for your business. I'll leave you with before we do Q&A with a little war story on this. I'm going to pick on nursing homes here, senior living. For some reason over the years, I've seen a bunch of senior living clients of ours that actually, for their current employees, have pushed this line of having them volunteer. So, for example, they'll say, we're going to have an ice cream social for all the residents of the home and their families this Saturday, and all of the nurses who work here are strongly encouraged to come, quote unquote, volunteer their time to scoop ice cream and schmooze with the families and break down afterwards and so forth. That's the kind of fuzzy line that you don't want to cross. We had a client in this industry a few years ago that actually had a Volunteer of the Month award for the employees that it had that volunteered the most of their time for these like ice cream social kind of things and like doing deferred maintenance around the property and what have you. And it came with a little plaque, right, the Volunteer of the Month award for employee volunteering their time. That plaque was later known as Exhibit A to the employee's attorney. So careful, nonprofits, not to lean too hard on volunteers. So I'll cover this in just 1 minute here. I probably said a lot of things that scare you today. When I do these presentations live, I see a lot of people looking like ghosts in the audience and furiously scribbling down notes as to things that they think they may be doing wrong. So the best thing you can do with this information I've given you is do a self-audit. Go back. Don't wait for, a plaintiff's attorney or the Department of Labor to find one of these problems for you. Go back and do some digging and figure out where you may have people misclassified already. I gave you some of these scare stories at the beginning about how much litigation has exploded and how expensive it can be and so forth. This truly is a place where an ounce of prevention is better than a pound of cure. It is as difficult and painful as it can sometimes be to find these problems and fix them up front is a fraction of the expense and pain and risk of getting sued over one of these things.
Excellent. Neil, thank you. That was
Pleasure.
Fantastic. You jammed so much information into a 45-minute window. Really, really fantastic information. Looking now to the questions that we've got, we have a few here that are in queue. This one came up a little earlier, and I think you've just started to cover it. Mm-hmm. But the person is asking, okay, so I've identified that I do have a misclassified employee.
Okay.
Where do I start?
Got it. And I'm going to assume misclassified is exempt, probably, because that's the most common issue. So it can be very tricky to communicate to somebody how and why we are switching them from exempt to non-exempt. Obviously, they're going to be impacted by it. Sometimes people are upset about it, right? I mean, there's a certain prestige and cachet that go along with being a salaried professional. And so when you tell somebody, like, we're going to switch you to non-exempt now, and so you've got to punch the clock, just like the janitor does, sometimes people take it as a blow to the ego, a demotion. So you want to be really careful about the way you communicate this. And, of course, you also don't want to make them suspicious that maybe we should have been paying them overtime for the last 3 years and, go talk to a lawyer or what have you. So there's a couple ways to accomplish this communication. Number one, if the change from exempt to non-exempt can be wrapped up in some other set of changes, so we're restructuring departments or changing reporting lines or updating job descriptions or anything that it can be folded into so the change from exempt to non-exempt doesn't stick out like a sore thumb, that's a good thing. A couple of other communication strategies. This one I'm about to do will work, but only if the facts actually back it up. So you can say to an employee something like this: we know you've been working hard and working some long hours recently. We really appreciate your dedication and hard work, and we want to make sure that you get rewarded for that time. So what we've decided to do is actually to switch you from salary to hourly so you can get overtime pay when you put in those 50, 60-hour weeks like you've been doing recently. The idea behind this being you're going to get paid more money, right? So we're going to set your hourly rate at a place where if you work 50 hours next week, you're actually going to take home more money than you did last week when you worked 50 hours. The idea is you're trying to get the employee that we're changing to see it as a benefit, to think, oh, great, I'm going to make more money now, and hopefully not be upset about it or think, well, why wasn't I making overtime before? Now, obviously, that one only works if it's actually true. And also, if you're going to do it that way, then you can't turn around a week later and say, oh, no, you can never work overtime because we can't afford it. You can only work 40 hours a week because you're going to undermine your whole communication there. Last option or tip I'll give on this is something that's like pretty close to coming clean without actually admitting that maybe we did something wrong. So it sounds like this. At company XYZ here, we want to hold ourselves to the highest ethical standards. We do reviews from time to time. We want to make absolutely sure that we're not even getting close to a gray area where we might be breaking the law or not treating somebody right. So we did some reviews, and the law has been in a big state of flux recently as to how we pay people, and in an abundance of caution, just to make absolutely sure we're treating everyone right, we're going to switch these positions from exempt to non-exempt. Okay? So again, we're not admitting like, oh, we screwed up, we should have paid you overtime for the last 3 years, but we're being pretty forthright about the reasons why we're doing what we're doing. Any one of those strategies can work. You just got to mold it to what your facts on the ground are, basically.
Excellent. We do have another question. The question is, if we hire and pay an undergrad student who's fulfilling the requirements of an internship for their degree completion, and we call the position an, quote, intern, but classify them as an employee, is that permissible?
So we call them an intern, but classify them as an employee. By saying classify them as an employee, I assume that means we're going to pay them. And if that's the case, that's fine. So the label intern is is really meaningless in the law. The law doesn't even use the term intern. That's a business world term. So the key distinction is this person an employee or not? If they're an employee, then we've got to pay them minimum wage and overtime.
And they're saying they're going to pay them.
Yep.
Yep.
Okay. So yeah, you can call anyone an intern you want. All I care about is whether you pay them or not, and whether you have to. So let's not get hung up on labels. Yep.
Okay. Excellent. One other. Here we go. We've got another one. What if someone goes from exempt to non-exempt and wants to work through lunch to get full 8-hour days, or longer if he or she comes in later and leaves earlier than other employees?
Okay. So a couple things to think about here. From a minimum wage and overtime perspective, that's perfectly fine. All right. For minimum wage and overtime compliance, all we have to do is get an accurate record of how many hours someone actually worked, whatever schedule it might be or whatever the breaks might be or what have you, and pay them minimum wage and overtime correctly based on those hours. So that's fine. The caveat to this is that a set of laws we have not talked about today are break laws. So there are certain states that require employers to permit employees to have breaks at a particular time. If the person asking this question, if you happen to be in Illinois, you should know that in Illinois, if someone's going to work a shift of 7.5 or more hours, we have to, quote unquote, permit them, and I'll get back to that in a second, we have to permit them a break of at least 20 minutes starting no later than 5 hours into the shift. So in Illinois, shift of 7.5 hours or more means permit a 20-minute break starting no later than 5 hours into the shift. Now, the question that you're thinking right now is, okay, well, we're permitting it. They could take the break if they wanted to, but they've chosen to work through lunch instead. It's their deal. That's what they want to do. We have been told informally by the Illinois Department of Labor over the years that they interpret permit to mean require. In other words, their position is you must actually force every employee to take a 20-minute break or a break of at least 20 minutes starting no later than 5 hours into the shift. I'll get to my soapbox for a second. I think that's a totally unreasonable interpretation of the law. Permit means permit. And so if the employee has the option to take the break, then I think we're complying with the law. But you should know that's not the Illinois Department of Labor's position. And if they, for instance, were to come in and audit you, they will look at your time records, and if they see people working more than 5 hours, more than 7 hours, more than 8 hours with no break registered, that they may push back and try to fine you for that.
Got it.
Yeah.
Excellent. Neil, fantastic. Thank you so very much. That concludes our Q&A session. And obviously, as you heard today, Neil is a wealth of information and really a trusted advisor to many, many corporations. So certainly, if you find yourself in a predicament, we've got Neil's contact information here on the PowerPoint. We will be sharing this PowerPoint with all the attendees of today's call, and we will certainly also notify you once our recording is live and available to be accessed. We will go ahead and with this conclude today's event. Thank you so much for joining us, and we'll let you know as soon as we have the related material posted to our website and our social media channels. Our next webinar, if you'd like to go ahead and mark your calendars, will be held on Thursday, June 22nd, same time, 12 o'clock noon. Details on the next webinar will be posted to our website and social media channels. And we wish you all a great day. You may now disconnect your lines.